For the bench conference, Your Honor. With regard to this case itself, we are asking to set this matter for preliminary examination
Discovery is complete.
to the best of my knowledge.
People have their witnesses available tonight. All right. Preliminary examination in person will be set June 9th, 2026, 9 a.m. before Judge Garwood.
And if I may briefly address bond, Your Honor. Your Honor, my understanding is that we're hearing a violation. I did receive that this morning. It's not far off from what my client and I discussed. I would just add, I'm learning from that situation. My client does currently work at Underground Printing on Whitaker Road. He has a really good job there. My understanding is that he would be able to keep that job. He has one daughter who is going to be turning 3 on June 7th. He would ask to be out for that. He's also got 2 other boys as well that he takes care of. One's 10, the other is 5. He financially supports all 3 of those kids. He just made his child support payment for 2 of his children and would definitely like an opportunity, should the court so allow, to be out so that he doesn't end up with a felony non-support. As a result of that, he is willing to wear a scram tether, GPS tracking tether, whatever the court might provide for safety to himself and the public. He does have the support of his sister and his girlfriend who are here today. His girlfriend did also write the court a letter speaking to that. Alternatively, Your Honor, if the court is unwilling to release him, I have talked to Mr. Cook. We would be asking for a release in patient treatment once a bed becomes available.
I will sign an order. I don't need a response. I'll sign an order for inpatient treatment. Once that's presented to the court, I don't have a problem doing that.
Okay.
With regard to his release at this point, I am disinclined to do that, so I'm going to deny that request. And his bond will continue, and certainly after the exam, the examination judge can relook it.
Certainly. All right. Thank you very much. All right. Assistant Public Defender Jay Bellinger on behalf, but not with Mr. Butler. Your Honor, my client is listed as homeless. He doesn't have a phone number or a valid email or any way that I can reach him. I understand that we did a warrant recall last time. He didn't show up. He does call our office after the fact. Unfortunately, no one collected a number from him that I could reach him on. So I will be working on getting one of those. I don't know if the court would at least consider another warrant recall should I end up in touch with him.
Any response from the people? Oh, all right. Here, he calls. I see that he has done the recall, and then somehow or another things are lost.
My understanding last time he was here was that he was informed by another defendant who was before this court, who saw him in person after court and let him know that he had a court hearing. He did call our office after the last bench warrant recall. We did, to the best of my knowledge, give him the date for today.
Normally, I would issue a bench warrant. What I'm going to do in this case, I'll continue his bond. Give you 2 weeks to get him here.
Okay.
11, 2026.
Thank you very much.
Court calls the cases 1, 2, 3, 4, 5, 6. Well, no, 6 on behalf People versus Gerard. Uh-oh.
Ashley Hannibal for the defense, Your Honor, requesting permission to practice.
Speak up, speak up, speak up.
Requesting permission to practice pursuant to Michigan Court Rule 8.120 under the super.
Who wrote that down for you?
Cannon.
Oh, you're with Cannon?
Yep.
I'm sorry. Okay. Go ahead, you can finish.
Under the supervision of Assistant Public Defender Stephanie Cannon.
Got it. All right. Where'd you go to undergrad?
Michigan, Your Honor.
Where are you in law school?
Minnesota.
What?
University of Minnesota, Your Honor.
I should. Yeah. Minnesota? Golden Gopher.
Yep.
Okay. Where are you from?
Michigan.
Okay. Do people actually go to Minnesota? I like Minnesota. Everything's underground. Permission to practice is granted.
All right, thank you.
Your name, sir?
Brian George.
Thank you. All right, what are we doing?
We'd like to set preliminary examination on all 6 matters.
Okay. Discovery is complete.
I believe so, Your Honor.
And would the people have their witnesses available on tonight? All right. Who else is doing this? Preliminary examination in all 6 matters will be set for June 9th, 2026, 9 a.m. That's before Judge Barr.
All right.
All right, Bond will, thank you.
I was released to treatment and
All right, he's gonna have to move. Court does call the case of the people of the state of Michigan versus Sean Call.
Assistant Public Defender Davi Lebo for Mr. Call. Mr. Call, can you tell the judge your name?
Sean Call. I have before me a plea form that it indicates that the defendant will be pleading guilty to the charge of larceny less than 293-day offense. Upon a successful plea to that charge, count 1 would be dismissed. And defendant agrees to restitution to be paid at the time of sentencing. That's the court's full understanding of the agreement.
That's correct, Your Honor.
May I have him sworn?
Right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
State your name, please.
Sean Call. Sir, it is this court's understanding that you're going to plead guilty to the charge of larceny less than $200. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $500, that would become the maximum fine. You understand that?
Yes, Your Honor.
All right. You understand also, sir, that while in taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Perry in the 15th District Court.
Yes, Your Honor.
All right. Still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, Your Honor.
All right. You signed an advice of rights form. Is that correct?
Good, Your Honor.
Any questions regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on them.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you in any way?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, I am.
And because you believe that you're guilty of this offense?
Yes, Your Honor.
September 8, 2025, at the location of 328 South 5th Avenue in City of Ann Arbor, Washtenaw County, State of Michigan. What'd you do that makes you think that you're guilty of that offense?
I bought some groceries at the store with a card I had found in the street and a wallet with no money in it.
Okay, so prior to you going into the store, you're saying that you found a wallet?
Yeah, I got off the bus on Gulf side in between Platt and Washtenaw, and there was a wallet in the middle of the street, no money. And I think I had gone to Kroger's or Myers and bought some cat food, and the cards I used didn't work. I kept using cards that I had, and I guess, I used that one, and I used my ID. So, obviously it came back to me. So guilty.
Your Honor, may I,
Oh,
here?
Please.
Sorry.
Mr. Call. Mr. Call, on the date and time that just discussed, did you use a Cash App card at the Kroger?
Yes.
And was that your Cash App card?
No.
Did you buy cat food with it?
Yeah.
Oh, and had anyone given you permission to use that Cash App card?
No.
Yes, sir.
Thank you.
All right. Sir, I do have to advise you that if I accept your plea and you commit misconduct between the time I accept your plea and the time of sentencing, you would not be entitled to withdraw your plea, and the court would no longer be bound by any sentence evaluation or recommendation. You understand that?
Yes, Your Honor.
All right. People aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor. Thanks.
And none from defense.
And have I complied with the court?
Yes.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing will be June 16th, 2026, 8:30 before Judge Perry. Bond will continue. Thank you.
Thank you, Your Honor.
Court does call the case, People versus Amanda James.
What do you think about the judge's decision in this case? Share your thoughts in the comments below. If you found this courtroom breakdown insightful, like, subscribe, and turn on notifications. Thanks for watching. Join Justice Frontier for more real courtroom analysis and legal breakdowns.